All right, describe the Fourth and Fifth Amendment. Within your response, explain what double jeopardy and self-incrimination is, and a court case that pertains to self-incrimination that we discussed yesterday in class. So I showed a video on the rights of this court case that was established from this court case and what that means.
Yeah.
Yeah. Gotcha.
That's nice to see. All righty, Fourth Amendment. Describe what it is. What is a Fourth Amendment here? Jeffrey?
Fourth Amendment states that one cannot be held to another trial of a previous crime that they already.
Okay, all right.
So it states that no double jeopardy, and if say someone commits a crime but they don't have significant evidence, or they don't read the Miranda rights, or something was wrong with the trial, they cannot be tried again for the same crime. trial.
That's more the Fifth Amendment. Double jeopardy, self-incrimination. Fourth Amendment is unlegal searches and seizures, right? There you go. All right. But anyway, what is double jeopardy? Go ahead. So Fifth Amendment, double jeopardy. What is it? Go ahead, Sarah. Yeah, you can't get trial for the same crime. Good job. Good job. So if you're already trial for a crime, then if you already go through that process, you can't be tried again for it. Good job. Good job. And then self-incrimination, what does that mean? Self-incrimination. Jamie?
It's like, okay, so I don't know how else to explain it other than like you have a right to like shut up.
Okay. All right. Yeah. So you don't harm yourself, right? And let's say you're being questioned by the authorities so that you don't do your own harm to yourself to the point where you could put yourself in danger or see jail time from it. So whatever words that you are explaining, what you are saying, yeah, good job. It's the right to shut up. Okay, it's a good way to put it. I like that. Yeah. All right, Fourth Amendment on illegal searches and seizures. That's what we talked about. And we talked about warrants yesterday for the Fourth Amendment. What is a warrant? What is a warrant? Rem? Yeah.
It's like when they get to court stating that they have the right to arrest you or search your vehicle or your house.
Your property, right? Yeah, good job. Good job. Awesome. Good. And we talked about how police officers have the ability to kind of skip that process. And how can they? How can they? What are some examples? Terrence, do you have one? Maybe they don't need a warrant to search your property, your car, your home. Routine.
See something in your car.
Yeah, good job. Good job. So maybe if there is a reasonable cause, right? So maybe there is something that looks a little fishy, right? Maybe there's something that they sense in the car that could cause damage or that is illegal. Then they have the ability, like a routine traffic stop, to search your car. Good. Sarah? Yeah, good job. So immediate danger. If they see the process, if they actually witness this going down and see something that is obviously alarming, they have the ability to search your possessions. Good, good. Anything else? Madam? Oh yeah, good job. So if let's say trash is outside waiting to be picked up by the garbage man, then they can search that as well. Good, good, awesome. I think we're pretty good with that. All right, what about a court case with self-incrimination that we talked about yesterday? I know I showed the clip at the end, kind of detailing about that these rights that are expressed. Go ahead, Tanner.
There was Escobedo versus Illinois.
Yeah, what was that about?
Manuel Volterra was shot and killed in Chicago, and police picked up Escobedo and questioned him at length.
Yeah, good job. Good job. To the point where he admitted to really everything, right? And maybe to the point where he actually said some things that weren't true because he was so nervous about being questioned and interrogated about the situation. So he might have actually gave false information because he was so nervous. He was under pressure of the police. And with that Fifth Amendment with self-incrimination, he didn't have the right to a lawyer. He didn't know his rights, and he could have just remained silent, or he could have just said, I want to speak to a lawyer first before going through this process. All right, good, good. And then what else do we talk about? What other court case? Brock? Yeah, good job. And what did that establish? That the police officers have to say when they're arresting someone. The Miranda rights. Yep, good job. So if you don't know your rights, okay, the police have to, before making arrest, speak these rights to you so you know them, and you understand them. And if they're not spoken to you, chances are you can get away scotch-free with that. Just like in 21 Jump Street. I always think that part's funny. Oh yeah, you have the right to be an attorney if you want. All right. No terms for today. That's it. That's it. I want to get into the lesson, talk about the Sixth Amendment today and court cases that pertain to that. The Eighth Amendment, and then I have an assignment for you that you can work on in your textbook. So it shouldn't take you too long. Well, I want to show a video too about the one court case. All right, Sixth Amendment. What is it? Anybody know off the top of their head? Jeffrey, you know? Oh, I just saw you in deep thought, so I was just wondering. Sixth Amendment. What is it? What is it? There's a couple things to it, I guess. Madden, do you know? Well, I don't know. You listed them on that PowerPoint one time. You said you knew them. Sarah? Yeah, good job. Okay, good job. So right to a lawyer. Good, good. Awesome. So what else? What else? Brock, you know? Speedy trial. Yeah, good job. Good job. Awesome. So the Sixth Amendment guarantees right to a fair, speedy trial and a right to legal counsel, a lawyer. So it's open to the public, jury of impartial peers. Defendant is able to hear the evidence against him or her. So obviously, they need to hear that evidence so they can prepare to defend themselves. Accused is able to defend him or herself, present evidence in his or her own favor, and trial takes place in a speedy manner. So why is it important to have a trial that is in a fair amount of time and a speedy amount of time? I guess you could say speedy trial. What does that mean? Why is it important? Jeffrey?
Could lead to tampering of evidence, could lead to.
Okay,
matters
tampering of evidence.
that doesn't relate to the court case, but could be related to the court case under different circumstances.
Okay,
And could lead to people stacking up jury.
all right, okay, good. What else? What else? What about people that were maybe witnessing the crime?
Maybe forget.
Okay, yeah, good job. So to try to have it in a quick amount of time so people don't forget the details of a certain event and to make sure that evidence is acquired in a certain amount of time. And any evidence used afterwards, which we already talked about with the Fourth Amendment, could be unconstitutional. Good. So the Sixth Amendment, again, guarantees for fair, speedy trial and the right to counsel, a lawyer. The speedy trial is everyone's best interest for a trial to take place soon after charges are filed. The reason for it is for evidence being collected and just a plain simple fact that many people forget after a long period of time. All right. So to make sure that these memories of, let's say, witnessing the crime is fresh in people's minds. So speedy trial. All right to legal counsel. So Sixth Amendment also guarantees a right to attorney. And the reason for it is just because many people might not have the ability to express themselves in the courtroom. Maybe they're not as informed of the judicial system as what they should be. And they might need a little help to help prepare their claims in court. We all know that states supply a lawyer too, just in case you can't afford one. All right. And that wasn't always like that, which is interesting enough. So we'll talk about the 14th Amendment today in a court case, which pertains to supplying a lawyer to people depending on the crime, obviously, and the sentence of the crime. So let's say if it's past 6 months, then the right to a lawyer is needed and to help defend these people and the rights of the accused. So originally, states were not required to provide a lawyer, which is interesting enough. That changed right around 1963, 1964. And we'll talk about the court case today. So first court case I want to talk about, 1942, Betts versus Brady. Okay, this was a court case that was dealing with punishment less than a death penalty. It was about robbery. So Betts, he was actually in Maryland. He robbed, I think it was a bank. And as he was sentenced for a 6 or 8 year sentence for a crime in jail, he realized he wasn't supplied with a lawyer. And looking back at it, he was like, well, this is going against my Sixth Amendment. I should have the ability to have a lawyer to defend myself in the courtroom. And that didn't work out for him in the 1940s. Okay, and this decision was made. And this was kind of setting precedent moving forward that all states kind of had a difference when it comes to supplying a lawyer to a defendant. And why do you think maybe states decided not to supply a lawyer to someone or provide a lawyer for, let's say, these people that are facing a crime? What do you think? What do you think? What's it gonna do for the state here? Go ahead, Ram. Never mind. What were you gonna say though?
I feel like Colorado instantly begin the act.
Okay, there's no point then, huh? But still, they should have a right to a lawyer. Okay, Tanner?
Stack up odds against
Okay, all right, yeah, yeah, good job. So to make sure that they can easily put this person in jail, no problem, and to punish this person. Okay, so that might be a reason. Why else? Why else? So that lawyer needs to get paid, right? So who's footing the bill? Go ahead, Sarah. Yeah, by the state, the tax, yeah, tax money, right? So the state's like, we just can't do this for every crime. This would be ridiculous, right? And that's why in the 40s and moving up in the 60s, which we'll talk about, changes with Gideon versus Wainwright. Uh, that's why kind of the states didn't have a reason and sometimes contradicted the Sixth Amendment because they didn't want to supply a lawyer to every single person that's facing a crime because that would cause the state to face a lot of loss and a lot of loss of money. So Gideon Wainwright actually overturned Betts versus Brady. Very similar aspect here, but this was in Florida in the 1960s. He actually robbed a pool hall, which is like a bar. And as he was stumbling out of this bar, people said the firsthand account that they saw him with a bottle of booze, and he was stumbling out of the bar, and he had a bunch of money with him. So they said he robbed the pool hall. And as he was facing jail time, he actually served 5 years, and he wasn't required a lawyer. He actually asked the state of Florida for a lawyer to help him in his sentence and help him in his court case. But they rejected him. They said, "Nope, we're not going to supply that to you in our state. We don't have to follow this type of action." And because he was serving 5 years, which is a long, long time, as he was sitting in jail, he was reading through some of these court hearings and politics and government books, and he's realizing, you know what, my Sixth Amendment wasn't held up right. Okay, he didn't have this right, and he felt like he was kind of stripped from the Sixth Amendment, stripped from this right. So he fought up and fought against it, and the Supreme Court actually took this case up and eventually and actually overturned to a point where he was set free and he was given compensation for his jail time of 5 years. And it just goes to show with the 14th Amendment that certain states just can't decide whether what amendment or whatever government amendment that they're going to follow. It's not like they can just decide which amendments to follow and what to not. So the 14th Amendment with due process proved that the state of Florida, depending on the crime, as long as it's more than 6 months, have to provide a lawyer to the accused, to these people that are facing a crime. All right, and that's pretty much what I said here. So this major landmark case, the Supreme Court ruled that everyone facing a jail sentence of 6 months or more has a right to legal counsel. All right, and it's not up to the states to make that decision. This is a nationwide amendment. This is an amendment. Okay, this is something that the whole nation, every state has to follow. Like I said, this is overturning Betts versus Brady. So we'll hear more about Gideon versus Wainwright with the video, and then I'll get you working on the assignment. Finally, the last amendment I want to talk about, the Eighth Amendment. What is the Eighth Amendment? What is it? No cruel, Madden? Yeah, there you go. No cruel, unusual punishments. And this is kind of left up to the states of exactly how they want to push for this extent. Some states are a little lenient, some states a little bit more involved, depending on the crime. Obviously, if it's like murder or something that severe, the death penalty could follow. And there are actually some states that go along with using still hanging, electric chair, which I think is interesting. There's still 2 states in the country that use an alternative method other than lethal injection as a way of the death penalty, which is, I think, pretty interesting to think about. And same with electric chair. But mostly the lethal injections used for crimes that involve the death penalty. But also, this is just as simple as maybe 2 people sharing a jail cell. Depending on how big that cell is, depending on how maybe large the room is, this could be viewed as a punishment, an unusual punishment of sharing a jail cell with someone, depending on how large the room is, which I think is interesting. All right, so you guys can read about that with the assignment today of the Eighth Amendment. There's actually a cool figure on page 404 that shows capital punishment in the United States and what states are a little bit more lenient about it. Maybe they don't even have capital punishment at all with the death penalty. And some still utilize, like I said, hanging, electric chair, which is kind of shocking to think about. All right, so your assignment for today, put that up now. You're just going to read through chapter 14, section 3, and complete the assignment here relating to court cases dealing with rights of the accused. Under modules, we'll see it here. The rights of the accused. So here's the assignment. Like I said, you'll just read through chapter 14, section 3, which is 398 to 405 to complete this assignment. This is what it looks like here. All right. So before we do that, I want to show a video of Gideon versus Wainwright.